Okay, I think we'll get underway. Hi, everybody, and welcome to Arnold & Porter's ESG investigation series, navigating the minefield of state AG, DOJ, and FTC enforcement risk. My name is Eric Walsh, and I'm counsel in the firm's financial services group. Before we get started, I just want to go over a few housekeeping items. If you would like to submit a question, please select the Q&A icon located at the bottom center of your screen and type your question into the Q&A window. Due to time constraints, we might not be able to get through all the questions, so please do not hesitate to contact any of us directly following this event. The ebook that we will be providing at the end of this presentation contains speaker bios and additional supporting materials. So be on the lookout for that at the end of this webinar. Additionally, for anyone seeking CLE credit for the presentation, the instructions on how to submit your request for accreditation will also be included in that follow-up email along with the ebook. So on to the program. The increased political attention to ESG has really narrowed the tightrope that companies must walk in deciding whether and how to advance their ESG agendas. On the one hand, investigations against quote-unquote woke companies have begun and will continue in earnest in conservative states and in Congress, especially now with Republicans controlling the House. On the other hand, shareholders and other stakeholders, including attorneys general from blue states, continue to push companies and lawmakers to adopt ESG initiatives. In this series, we're going to provide our views on how companies can best walk this tightrope. It's not easy, as many of you know, and you'll understand through these discussions that we have. We're going to provide an overview of the current and anticipated ESG-related investigations and enforcement trends, and we will discuss the practical, legal, and reputational considerations in responding to such inquiries. We'll also discuss how your company can best position itself to avoid scrutiny in the first place, or at least to help strategize how best to respond to government inquiries should your company nevertheless be targeted. For this first panel in our series, I'm going to start off by covering the most recent investigations that state attorneys general have launched against financial institutions that are members of net zero alliances in their investigations into ratings agencies and proxy advisors. I'm joined today by three of my colleagues. Andre Gevarola and Francesca Pisano are members of Arnold & Porter's antitrust group. They will be discussing the intersection of ESG and antitrust with attention to managing antitrust risk in industry collaborations. This is a particularly important topic in today's era of increased antitrust enforcement. I'm also joined by Rakia Pippins, who is the head of the firm's consumer products practice group and the consumer products and retail industry team. Rakia will discuss FTC consumer protection precedent related to ESG with a focus on FTC scrutiny on greenwashing claims. Today and throughout this ESG series, we will be discussing the unique government requests and considerations in how to respond to them. And these are going to be focused on investigations involving polarizing and political topics, as many of you are well aware. At our next session, which is going to be on May 10th, members of the firm's legislative and white-collar groups will be discussing how to handle congressional investigations on matters related to ESG. And then we'll have two additional panels, dates to be scheduled later on, one on internal investigations on ESG-related matters. And in that presentation, we'll also discuss ESG-related due diligence on corporate transactions. And then we'll have a panel on SEC investigations on ESG-related matters. That session will also include SEC disclosure requirements. And so we've scheduled that one for last as we all wait patiently for the SEC to issue its climate disclosure rules. So state AG investigations, which is how we're going to kick things off. Just to level set a little bit and to be sure, it's worth pointing out that these are certainly politically sensitive and even partisan investigations. Most people likely are aware that the state AG investigations are being led exclusively by attorneys general from Republican states. And the anti-ESG rhetoric and promised ESG investigations were, in fact, central messages to many Republican campaigns at both the national level and state level, including state AGs. AG investigations into the Net Zero Banking Alliance and Net Zero Asset Managers Initiative, and into the rating agencies and into proxy advisors, which we'll touch on today, all have been launched by Republican AGs. There's no Democratic attorney general who has launched such an investigation. And to underscore just how political these investigations are, certain state AGs launched their ESG investigations, or at least threatened them, within a week of taking office. And to underscore it even further, Arizona recently elected a Democratic attorney general who promptly ended her Republican predecessor's investigation into the Net Zero Banking Alliance members. So let's take a look at some of these investigations. We're going to touch on what the AGs are saying in their press releases announcing the investigations. And then we'll look at what some of the requests the AGs are making in the civil investigative demands or the subpoenas that are being issued in connection with their investigations. Several states are prohibited by law from disclosing the civil investigative demands, or CIDs. Other states, though, publish them right on the state AG website, and they're worth taking a look at. The reason for that is the requests in the CIDs don't always match up with what is being stated in the press release. And so if you receive a CID like this, it's really important to understand what's literally being requested of you versus what the motivation may be behind the CID, or maybe a broader, more general subject that the AG is investigating, which you can glean from the press releases. So we'll take a look at the press release version of the investigation and the CID version of the investigation. The reason this is important is because when you get to the point of potentially negotiating the scope of your response to CID, it's very important to have an understanding, okay, what is the Attorney General really most focused on here? So we'll start with the AG investigations into the ratings firms. With the upsurge in interest in ESG investing, ratings agencies understandably have introduced ESG-related scorecards assessing how companies fare on a number of ESG factors. Since the summer of 2022, a number of red state AGs have sent subpoenas or CIDs to two of the leading ratings agencies. And if you look at the press releases that accompany these CIDs, you see statements from the AGs that say things like consumers and investors are being hurt by the woke ESG movement and that movement's obsession with radical social change. You'll hear the AGs saying that they are therefore investigating the ratings agencies to find out if they're engaged in, quote, destructive and illegal business practices. And if so, they'll have to pay for their actions. What the AGs are saying is that the ratings agencies, through their issuance of ESG ratings and scorecards, are politicizing what should really be a purely financial decision. And on the state AG investigations into the rating agencies, there's also this sort of secondary but related issue that they've been focused on, which is accusing the ratings agencies of inserting an alleged anti-Israel bias into their ESG ratings. So a lot of the requests have to do with Israel and in the BDS movement. What's interesting is that the requests themselves, so what is actually being asked for in the CIDs, and this goes for each category of state AG investigation that we'll talk about today. It's a combination of pretty straightforward requests, type of requests you would expect for what is purportedly being investigated. And so for the ratings agencies, there are requests like please provide documents sufficient to identify the sources you are consulting for determining future ESG factors in ESG scorecards. That's pretty standard. That would be anticipated in an investigation like this. But there's also a lot of political theater involved in these CIDs. And this is something we'll come back to at the end, like how to address this. So as an example, in the ratings agency CIDs, there's a request. How does energy independence of free and democratic countries and their reliance on fossil fuels from domestic producers factor into your ESG scorecard, when there should also be a consideration about relying on countries that are ruled by an authoritarian government that violates human norms for your energy sources? And the request is worded that way, in that very loaded way. And the question that a lot of people get when they get a request is, how the heck am I supposed to respond to that? And we'll come back to kind of like chopping through the political aspects of that and how to respond to that in a practical way. State AGs have also sent letters to proxy advisor firms. This so far has not been an official investigation. These are letters, which are really warning letters to the proxy advisors and threatening them for what the AGs have seen as proxy advisors recommending votes against directors of companies if the company is not implementing emissions reduction targets, or if the board of the company is not sufficiently diverse. I'm pretty sure the proxy advisors would say that that's not exactly correct. That's not exactly what they're recommending. But again, these are political investigations. And so the basis of the investigations there against or not investigations, but this sort of warning shot that the AGs have fired is that with these recommendations that the proxy advisor firms are making, the state AGs are saying you are potentially violating state and federal laws and your contractual duties, which require you to make recommendations that are free from false and misleading information, again, in the AG's perspective, and potentially in violation of anti-discrimination laws. And by making these recommendations, you're not putting the shareholders' financial best interests first. The AG investigations garnering perhaps the most attention, maybe the ones launched on October 19th by 19 state AGs into 6 US banks who are members of the Net Zero Banking Alliance. There are 9 members of the Net Zero Banking Alliance. Only 6 of them received subpoenas or CIDs. Probably not surprisingly, these are probably, I think, the 6 largest banks in the United States. The other 3 are much smaller. What is the Net Zero Banking Alliance? It's a UN-convened consortium of global banks. It's up to about 130, I think 129 banks now that have 40% of the global banking assets. And members of the NZBA have signed on to a commitment statement. And that commitment statement says that the members will transition all operational and attributable GHG emissions from their lending and investment portfolios to align with a net zero pathway and to reach that net zero goal by 2050. They commit to prioritizing their efforts where they can have the most significant impact. And so prioritizing their efforts with a focus on the most greenhouse gas intensive or greenhouse gas emitting sectors within their portfolios. And so how have the AGs who are investigating the members in this alliance portrayed this? They would call this and have called this a, quote, massive worldwide agreement. They also accuse the banks of ceding the U.S. financial authority to a foreign body, the UN, because these are under this alliance is under the auspices of the United Nations. And it's been interesting to see them the leadership of the Net Zero Banking Alliance, how they've responded to these investigations. And so there have been statements over the last couple of months from Net Zero Banking Alliance leadership clarifying that the members set their own individual targets. They make their own independent decisions on how to meet those targets. This isn't the massive worldwide agreement that the state AGs are portraying them to be. There's a similar investigation being launched into asset managers who are members of a very similar alliance, the Net Zero Asset Manager Initiative. Same commitments or similar commitments for members of the Net Zero Asset Manager Initiative. And so what we want to do here just pretty quickly is take a look at the types of requests that are included in the CIDs. If you look at the CIDs themselves, as they're required to do, they state the potential violations of law that the attorneys general are investigating. And each one of these that's publicly available anyway says that the AGs are investigating violations of the state's deceptive trade practices laws. But if you look at the requests, it's clear that what they're looking at goes much broader than a deceptive trade practice violation. And it's actually difficult to see how a lot of these requests would support a potential deceptive trade practice claim. So up on the screen here are some examples of the information that's being requested from members of the Net Zero Banking Alliance. Identifying customers in the oil and gas, power, and automotive sectors. These are referred to as covered companies. Information about when banks have declined to do business or exit a relationship with a covered company, due either directly or indirectly to ESG related goals, a very broad amorphous request. Information about ESG related conditions that the bank has imposed on covered companies in order for that covered company to maintain a relationship with the bank, and any changes that the covered companies have adopted in response to the bank's ESG related condition imposed on the covered company. It's also asked for, or these CIDs have asked for membership lists. They've been very unabashed about saying, if you're a member of a climate initiative, tell us all the other members who are part of that initiative and even who are the prospective members. So you can see we're getting kind of far afield from the deceptive trade practices that these investigations purportedly are meant to be focused on. And Francesca, I'll turn it over to you at this point and see, if you talk about some of the antitrust considerations that you see in these AG CIDs.
Sure. Thanks so much, Eric. So when we looked at some of the publicly available net zero CIDs, we did notice a couple types of requests in particular that to us really ring on antitrust issues. The first big one is that some of the CIDs are asking for antitrust related guidelines, policies, or training materials that are used by the parties who've received the subpoena. And that's obviously a good signal that antitrust is an issue of interest to the state AGs, but also a good signal that companies active in this area should be dusting off their antitrust training and compliance materials, even for ESG related activities. The second thing we noticed in several different CIDs focused on the net zero alliances are requests that specifically reference statements that were made by the parties that have language such as, we want to get the entire industry together to achieve these goals, or we are going to collaborate with our peers. And as we'll talk about, these are the types of requests we expect to see in an investigation where the authorities are looking into collaborations and arrangements among competitors and among players in the same industry. And they seem to be focusing in on and asking questions about the parties' own statements. So let's get in now to some of the antitrust substance, and I'm going to pass it over to my colleague, Andre.
Sure. So we'll spend a few moments drilling down into how the antitrust laws may apply to ESG activities. And first, I just want to highlight something that was mentioned earlier, which is when we talk about antitrust laws, of course, it's appropriate to be focused on the federal antitrust laws, but states also have their own antitrust laws, which the state AGs can enforce. Typically, these are modeled after the federal statutes. So the wording is very similar, but as many of us know, the way the antitrust laws are written are very broad and very lacking in detail. So that, I think, provides space for different enforcers to perhaps interpret the laws differently and apply them differently, especially in an issue that's as politically sensitive and it's such a political football as ESG. So let's move to the next slide. Just to level set, big picture, I think there is one thing that's clear and where there is bipartisan consensus, and that is that ESG is not immune from antitrust scrutiny at either the federal or the state level. Any collaborations among competitors, like industry initiatives or working groups, can raise risks of potential antitrust violations. And here in the slide, we've quoted both Biden administration antitrust enforcers, Lena Khan and Jonathan Cantor, as well as the Trump DOJ antitrust enforcer, Makan Delrahim. So, very much of different parties and political backgrounds, but they all were consistent in terms of how the antitrust laws do apply to ESG and how there is no exception to the antitrust laws just because you're engaged in ESG activities. So in terms of how those laws may apply, it could work in a couple different ways. For example, if there's an agreement among competitors to reduce output or restrict production of a particular product, even if that's being done for good reasons, such as environmental concerns, if competitors are doing it together, that could raise the risk of a potential antitrust violation. Second, if there's an agreement among competitors about what inputs they're going to buy and how much they're going to pay for it, whether it's materials or labor, or another related example is an agreement not to buy from certain producers. Again, if competitors are doing it together, there is risk of antitrust violations there. So in terms of antitrust and ESG, you really have to think more broadly than the traditional categories that you might think of, such as don't fix prices or don't rig bids. Whenever competitors are collaborating together, it's always important to keep antitrust in mind, even outside those traditional categories. And let's move to the next slide. So here's just one example that we wanted to cover. So this was around the 2020 timeframe. During the Trump administration, it was reported that DOJ opened an investigation into automakers that were involved in working with the state of California regarding emission standards. And there was a lot of debate publicly about whether this was a politically driven investigation, given the involvement of the state of California. And ultimately, the investigation was closed without action. And it was also reported that DOJ's concern, they said, was about whether the agreement could result in an artificial limit on the types of cars and trucks offered by the manufacturers, whereas absent this collaboration, maybe the manufacturers would offer a wider range of vehicles if there were not these standards that they were working on together. So that was the reason given for the investigation, or at least the reason that was reported. But again, there was debate about whether it was driven by kind of administration political reasons. But the real, I think, takeaway from this example is one, just because an investigation may have been initiated for political reasons doesn't mean it won't uncover real antitrust issues. It doesn't really matter how an investigation begins. It matters, what facts and evidence the authorities might uncover. And just looking to the quote at the bottom of the screen here, one of the executives participating in this collaboration, mentioned that as they were working on this, antitrust wasn't really on their radar screen, which I would hope today that would no longer be the case. Given how much antitrust has been mentioned in these issues, it really is important to keep antitrust on the radar screen and really as top of mind when companies are collaborating together, even on ESG issues. Next slide. So turning to the state investigations that we've been discussing, again, I think there's debate out there whether these are politically driven or politically motivated. And I think depending on where you come out, you might come out differently on that question. But again, it doesn't really matter because what matters is what facts are underlying the collaboration. And one thing I want to highlight is, especially these days, state AGs do work closely with their federal counterparts. So when you are dealing with a state AG investigation, not only is it important to keep that particular investigation in mind, it's also important to keep in mind the possible referrals that might come out of that investigation to the federal authorities. Because as we discussed, it's certainly the case that industry collaborations and pledges could potentially raise antitrust issues. And it's not clear where these state AG investigations are going to go. But it's important to know that is a risk that could arise both from the state AGs and from the federal authorities. And anybody who's been paying attention to the antitrust world knows that the Biden administration enforcers are pursuing a very aggressive antitrust enforcement agenda. They've already said there's no ESG exemption for antitrust liability. So they could certainly pursue anything that they see themselves or anything that's referred to them by a state AG. Ultimately, how investigations end will depend on the facts of each case. Antitrust is very fact specific. And ultimately, no matter how an investigation began, it's going to be decided on the facts that the authorities uncover, both with regard to whether there's liability, but also with regard to whether any antitrust immunities apply. And we're going to talk about those in a little bit. And we'll also talk about how to manage some of these risks. But for now, I'll turn it over to Francesca, who's going to discuss some of the key antitrust concepts and doctrines that apply to ESG activities.
Thanks so much. So we're going to do a very high level 101 before diving into the details and the application and best practices for ESG. So there's a number of relevant antitrust statutes, but the ones that are most critical in terms of assessing risk in ESG alliances are the Sherman Act, sections 1 and 2, which prohibits agreements in restraint of trade, monopolization, and attempts to monopolize. And the FTC Act, section 5, which prohibits unfair method of competition. As Andre mentioned, there's also state antitrust laws as well, which generally mirror the federal statutes. So antitrust laws are concerned with protecting all aspects of competition. And importantly, this includes competition, not just in the sale of goods or services, which is how a lot of us might traditionally think of antitrust, but also competition on non-price characteristics like quality, features, service, or sustainability or green claims. It can also cover the procurement or of sourcing of goods, services, or labor. So when you think about antitrust issues in any particular alliance or initiative, a key primary issue is identifying whether you are dealing with a competitor. And we call that, a horizontal, and it generally speaking raises more risk than if you were just dealing with suppliers or customers, which we call vertical. And collaborations with competitors raise the most risk under antitrust, but you have to think broadly about what company might be a competitor. So in addition to companies that might sell the same good or service as you, a company that might compete out of the same talent pool could be a competitor, or two companies competing for advertising space might also be competitors in that context, even if they don't operate in the same industry. So relevant to the ESG question is, an agreement among competitors to not offer a particular good or service, or to not offer a good with a particular feature that could potentially be viewed as an output restriction and a potential antitrust violation. Similarly, agreements among competitors to all not deal with a particular third party that could be viewed as a boycott. Can we go to the next slide? So a couple of notable enforcement examples that I think help illustrate this concept that could be applied in the ESG context. The first is not a US example, but in the EU and in Korea, there were collaborations among car manufacturers on how best to make technical advances to comply with new emission standards. So, but the EU and the Korean enforcers alleged that these collaborations, which were, legitimate collaborations, what we call spilled over into potentially problematic agreements. And in this instance, both enforcers alleged that the manufacturers allegedly not just collaborated on the technical improvements, but then agreed that each company would not exceed the particular emission standards. And the authorities alleged that this limited competition or competition based on innovative technology. Moving back to the US, an example a couple of years ago, the DOJ brought an antitrust action against an association of college counselors. And at issue were some of the rules that the college counselors had applying to their members. If you want to be a part of this association, you have to follow these rules. Now, some of the rules were purportedly intended to ensure that the college process didn't disadvantage certain students, for example, students that might needed or might have relied on financial aid. But DOJ alleged that the rules restrained competition among the colleges, and that resulted in competitive harm. Finally, a DC example, in 1990, the FTC challenged an agreement made by a group of trial lawyers working in an association. And this association members agreed that they would not accept new indigent representations unless fees for that work was increased. The association argued that the current fee structure was untenable, and increasing the fees would ensure greater quality of criminal legal representation. The FTC challenged the agreement, and the Supreme Court agreed, and it noted that the proffered social justifications for the agreement didn't make it any less unlawful. So let's jump to the next slide. And with this in mind, what are some best practices to keep in mind when you are thinking about ESG initiatives big picture? And I think about this as kind of 3 inflection points in any particular ESG activity. So the first is designing or creating or launching an ESG alliance or working group. So big picture, remember that interactions and collaborations between competitors raise antitrust risk, even if it's done in the context of a trade association. A good way to, at the outset, manage antitrust risk is to ensure that there are participants and representatives from any industry member that is interested in participating. So make sure that smaller companies, suppliers, customers, or consumers have a voice. And then as part of designing any organization, you want to make sure you have antitrust guidelines, you have antitrust guardrails to manage information sharing and best practices among the parties. So the next inflection point is sort of what the parties are doing once they are part of this association, particularly in the ESG context, if they're working with the association to promulgate standards for sourcing or design goals or other features that might impact ESG related goals. I would say the number one thing to watch for is to make sure that the participants remain free to compete against each other. So it's fine for an industry group to design standards or to say, you know, we'll strive to meet this benchmark, but all the participants should continue to make business decisions independently and should be free to exceed any standards that are set up by the group. And that's really the spillover risk that we talked about with the AdBlue investigations. You want to watch out for a legitimate collaboration all above board where the conversations sort of might spill over into particular potentially problematic areas. And that's the third area, is managing the occurrence or perception of spillover. And here it's really not just a question of making sure that participants don't cross that line, but it's also watching what public statements and press releases are saying to make sure that there's not an appearance or a perception of spillover. And you want to watch out for sort of press releases that may be promulgated and published by independent companies, but you want to give some thought to how it might look from the outside, or how, you know, put on your antitrust enforcer hat and watch out for parallel press releases that could be viewed as coordinated activity. As we noted before, we've seen these press releases cited in the CIDs for some of the alliances, so we know the enforcers are looking at that, and you just want to make sure that the guidelines and the antitrust rules are being followed both in form and also in function. Let's jump to the next slide. So I want to give a couple final quick comments to some other defenses to consider when you're thinking about antitrust risk in this space. And my top line point here is that all of these are fairly technical and have some pros and cons. So if you are thinking about ESG activities, especially with competitors, and if you think one of these defenses or immunities might apply, consult antitrust counsel early to make sure you're dotting your I's and crossing your T's and you're meeting the requirements here, because these are pretty technical. So the first one is the state action doctrine. And this holds that there can be immunity for private parties if a state government or some municipalities have delegated their authority to a company for a particular action. But this has to be clearly articulated, and companies' actions have to be actively supervised by the state. So we often find ourselves advising on this issue in a circumstance where parties are getting political pressure from a state government or another local government saying, like, you know, you should be adhering to this goal, or you should be doing this, or how are you promoting this? And it is very difficult to show that you are meeting all the necessary requirements to get state action immunity. So this is something that you should be working with antitrust counsel on, especially if there's kind of pressure or direction coming from the state governments. There's also Norr-Pennington immunity under the First Amendment for companies' attempts to influence the government, and that's really intended to encompass lobbying. And the important aspect here is that it does not cover marketplace conduct. So it generally covers petitioning and lobbying, but it doesn't really cover conduct like designing products or offering services or things like that. And the final thing to potentially consider and think through the pros and cons is that DOJ and FTC do offer a business review advisory opinion process by which parties can share the facts of their potential immunity and get an advisory opinion on the antitrust issues. However, and I think this is a really big however, those letters are not binding on the DOJ and the FTC, and they're certainly not binding on state AGs. So it's really not a lot of sort of legal comfort you get from those. The other big issue is that the timeline is really uncertain around this process, and the process can take quite some time, and the answers you may get will likely be sort of heavily qualified. So if you are thinking about immunities or defenses in this area, I would just urge you to consult antitrust counsel early to make sure your teams not only know the guardrails, but also generally speaking, as they're engaging with competitors, to understand that they know when to raise their hand if they've run into an antitrust risk area or found a red flag somewhere. Rakia, do you want to take it away from the FTC perspective?
Thank you. Thank you, Francesca. You really teed this up well. And I think one important theme that has come up is the way in which a lot of agencies can collaborate with each other, or how lessons from one can impact the risk that you're seeing for another. If we can go to the next slide. I know that we've had a lot of discussion of antitrust risk, but another huge source of risk and also guidance when you're dealing with ESG from the FTC perspective is from the Consumer Protection Bureau. And I believe everyone on this call should know this already, but the Consumer Protection Bureau is focused on protecting against unfair and deceptive advertising and other practices that impact consumers. And you'll see them be present not only from an enforcement standpoint, but with respects to policy guidance and regulations that they issue in the area. Next slide, please. When it comes to ESG, there are really two major ways in which you can expect and you should be paying attention to the FTC's interest in the area. For decades now, the FTC has been active in issuing guidance related to environmental marketing claims, and I'm going to spend some time to discuss that. But I want to note that another area in the ESG that is becoming more relevant is respects to disparate impact of practices on marginalized groups. And we've seen more and more interest in organizations in submitting reports to the FTC on practices that could negatively impact marginalized groups, whether with respects to ethnicity or other distinct factors. And so I think it's something to really keep in mind as we think about the role of representations in ESG and how it can create risk from a consumer protection perspective. The FTC, as I mentioned, does issue guidance related to environmental claims specifically, known as the Green Guides. The first version was issued in 1992. They've been revised in 96 and 98 and 2012, and currently are also being accepting comment for revisions. Generally, these guides provide guidance on how advertisers can speak to consumers directly on all environmental marketing claims, and also the FTC's position on how consumers could interpret the claims. So it's really an important footprint in understanding where their priorities can come with respects to enforcement in this area. Next slide, please. You know, as I mentioned, they are currently accepting comments related to an update to the Green Guides, and this is a part of the regular every 10-year review that they have put forth. They created an extension for accepting comments to April 24th, and we're currently working with several trade associations in perfecting comments related to the update in Green Guides. But in particular, the FTC has sought comment on carbon offsets and climate change, compostable, degradable, ozone safe and ozone friendly claims, recycled content or recyclability claims, energy use and efficiency claims, and organic and sustainable. And one thing that we really want to emphasize is that the FTC has been very active in attempting to protect its ability to pursue civil penalties. And after the AMG decision, and we've seen it through either the issuance of notice letters to industry on the FTC's position on particular advertising practices, or in pursuing rulemaking in certain areas. And this is an example when it comes to the Green Guides where we expect the FTC to really pursue rulemaking, and we should anticipate some activity in that space. Next slide. Another thing that's important to note is that the FTC has a very long history of enforcement and environmental marketing claims. And what we've just tried to do here is highlight some of the big and public settlements that have been in this space. One thing you will see is that a majority of the more recent enforcement action came between 2012 and 2014, which is a little bit after they updated their Green Guides. For this reason, it's really prudent to expect that there will be increased enforcement and focus on environmental related marketing claims from the FTC after they issue an update to the Green Guides. And to help anticipate where that may come, I'm going to cover in more in-depth some recent FTC enforcement cases that show what have triggered their interest and help you to kind of mitigate risk in thinking about how to protect against it going forward. Next slide. Now, it's been several years since this action. I don't want to go into too much detail on it, but I think many are familiar with the FTC's public investigation, eventually settlement with Volkswagen over different clean diesel and other claims. I think what is a great example to remind teams about here is the way in which inquiries at the state level or different public complaints that are filed about claims can trigger the FTC's entrance in this area. In 2013, the International Council on Clean Transportation and California's Air Resource this board conducted testing on the Volkswagen vehicles, and helped to kind of identify a potential issue between the claims that are being made and the actual EPA's emission limits. It was years later the FTC opened their investigation into these same claims. And so it's just a reminder of how they are too monitoring different reports or issues that are happening at local and state levels. And it can result in significant settlement or issues that go back years before when the investigation takes place. Next slide. A more recent example here that I think is really indicative of where risk comes from when it comes to green marketing claims is the settlements that the FTC had with Kohl's and Walmart regarding claims that were being made for products that contained rayon from bamboo, but were also marketed with eco-friendly claims. What's notable here is that the basis for the FTC's enforcement in this case was a failure for these companies to conform with the FTC's position that these practices were deceptive in warning letters that had been sent out years before. And reason why we're focusing on this in particular here is that the FTC is really taking advantage of the opportunity to send these notice letters when it comes to marketing claims. I think just today they issued a letter expressing their position about substantiation for health and safety claims. And it's why the updates to the green guides are really a huge indication of some trigger issues that can occur as you're making representations to consumers in the green marketing context. Next slide, please. Another, though, huge trigger are just general eco-friendly or eco-benefit claims, and especially those that are related to certifying bodies. There has been a history of public FTC enforcement when companies attempt to reinforce their efforts to be responsible when it comes to environmental related issues with certification bodies where it isn't disclosed that there's a material connection between the company and the seal or certifying body that is being used to tout the claim. And we've seen that occur across industries. It's not limited to one in particular. We have one that was dealing with mattresses and another in consumer health products. It's very, very, very broad. But it's always been a priority for the FTC to protect against instances where consumers cannot tell the difference between claims that are being made by a company versus claims that are independent of it. And I think as we're looking for areas in which the consumer protection side of the FTC may take an interest in this space, it's especially important to think about instances where material connection between your company and a third party that is talking about your commitment to ESG has not been disclosed. Next slide. So with that, I do want to highlight before we get into some ways to protect against or these types of investigations from the FTC that a really big source of risk are advocacy groups, and they are paying attention. And I think one example would be the complaints that were filed against Chevron by Earthworks. What I want to flag here is that it really touches on the two areas from that are a part of ESG that are likely to be focuses for the FTC Consumer Protection Bureau. The first being your green claims, which we just discussed, but the other dealing with issues that show a disparate impact on marginalized groups or unfair or deceptive practices in that it may negatively impact one group or another. And what was really interesting in this complaint that was filed was that it focused not only concerns about whether renewable energy claims were supported, but also on whether there was consistency between certain proclamations related to the Black Lives Matter movement that were being made by Chevron and the impact that the advocacy group organizations believed that Chevron's behaviors may have had on the Black community in particular when it came to higher pollution rates in those communities or related health risks. And it just shows an important example of the two angles that need to be thought about when playing in the ESG space to kind of protect against an interest from the consumer protection side of the FTC. Next slide. Now, while there haven't been a lot of any recent CIDs that have been sent out that we can discuss with you on ESG from the consumer protection, there are some lessons from the NAD that can be learned on how to properly substantiate and document support for these claims. And because we did want to leave an opening up for some questions, I just want to quickly flip through some notable examples from this organization, which has a very tight relationship with the FTC Consumer Protection Bureau, to kind of guide you on how you can make sure you have the paperwork and documentation necessary to protect against an inquiry from the FTC from a consumer protection perspective for green claims. Next slide. And so to quickly go through them, the first, I think this is a really important case to monitor. It was with JBS USA Holdings, an NAD case in which there were certain representations about commitments that were challenged, in which JBS was just in essence committing to get closer to net zero by 2040. And what was really interesting here is that the claims were found to be unsupported, not because JBS did not have an agreement. They did have an agreement with SPTI to hit these goals, but more because there wasn't a belief that there were evidence of practical, measurable steps towards achieving the goal that the company had put forth. Now, they are appealing the decision, but I think it's a really important reminder that it's no longer okay to just have an aspirational statement if you can't document how your company is actually intending to achieve that goal by the time period that's being set. And here an example would be, while the company did have an effort to maybe to hire a consultant to help do the gap assessment to see the differences between where they were and their goals towards being net zero by 2040. It was found to be inappropriate to promote this goal because the results of that were not back and there wasn't clear active steps on how to achieve it. And so I really want to emphasize the importance of there being practical documentation of how even aspirational goals can be achieved. Next slide. The Every Bottle Back campaign NAD case is also very helpful because it's a win. It's an instance where the American Beverage Association was able to support its claims that they were able to say that their bottles were made to be remade. And through this, they were able to provide their corporate responsibility report. They had a study by the Sustainability Packaging Coalition regarding the availability of recyclable programs that kind of supported their claims. And also they were able to kind of give information on its business partnership with third-party organizations to help show that there was a reduction in the amount of plastic that was going into how plastic was being disposed of by communities. And I think it's a helpful example of how you can create the proper documentation to support the claims. Next slide. Similarly, I really like this case that involved claims for Quilted Northern toilet tissue, in which they were making a claim that 3 trees are being planted for every tree used. And the claim was found to be supported because they had the proper documentation, not only of their agreement with the third-party organization Arbor Day Foundation showing their commitment to plant a tree based on the amount that was given, but also measures on the decrease, how that had changed their resource purchase and development over a 10-year period. And it's really a reminder of how important auditing is in these contexts in order to make sure that you have documentation to support the representations that were being made. Very quickly, because I want to pass it over to Francesca, I'll just note that there's a couple other cases involving Chipotle. You can skip ahead also, Eric, to the Butterball that show really good tips on how to document these claims. And I say this to say that we're here as a resource to help you protect against consumer protection challenges by letting us help talk through you good ways to document the representations you want to make, whether from an environmental perspective or regarding impacts from a social perspective to consumers. And so with that, I'm going to pack it over to Francesca, who's going to talk a little bit about how to mitigate all these risks. Next slide.
Thanks so much. We actually have some questions in from the participants, so maybe why don't we answer those and then we can go back if we have time to get into more detail. So I think the first question that came in is with regards to the Sherman Act, why would any company wishing to reduce its operational risk with actions that lower its exposure to a changing climate and severe weather worry about antitrust? Andre, do you want to start with this one?
Sure. And going back to what we discussed earlier, in terms of kind of having good and valid reasons for engaging in these business activities, from a Sherman Act and antitrust perspective, that's not really a defense. The key issue is, are you doing it with your competitors in a way that restrains competition? And if so, the fact that you're doing it for reasons that certainly may be valid isn't really going to get you out of liability. However, you're perfectly free to engage in these activities if you do so independently. What the Sherman Act is really concerned about is when competitors act together in a way that may limit competition between them.
And I think just to kind of add on a little bit, one of the examples we talked about was the Association of College Counselors. And I think that perfectly illustrates what Andre was talking about. Each college may have the ability to independently put in place rules and procedures and processes to make sure that students that need financial aid aren't disadvantaged. But when the colleges got together with each other, with their competitors, and started promulgating rules, it's kind of a mind to properly account for antitrust risk. You have to kind of shift the mindset from, okay, what is the reasoning behind it? And to think about like, okay, like, is it restraining competition? What is the result of the agreement or alliance or framework? We have another question, and this one is probably best directed at Eric. The question came in from someone who works at a US manufacturing subsidiary of a UK corporation that isn't SEC regulated here. To what extent might that company be at risk for alleged violative statements in the UK annual report, but with US liability, I think is the question.
Yeah, I think it depends a lot on the type of company it is, and if it's marketing or trying to attract US investors. So even if you are a UK company, if you're reaching out to investors in the United States, and that can be interpreted quite broadly by the US government agencies, meaning like if you have a website that US people can access, and it's about geared towards investing in that company, then there could be potential liability in the United States. Of course, as I mentioned, there are all sorts of variables to consider there, but you can, US investors can invest in foreign companies through, for example, ADRs, and the SEC has gone after companies that headquartered overseas, but are targeting US investors who are investing through ADRs, American Depository Receipts. So it's something to be mindful of for sure.
Fantastic. And then we have a question probably for Rakia. Rakia, is there a private right of action or monetary incentives for organizations or individuals to bring FTC challenges?
So it's interesting. I'm going to get to the broader question. When it comes to green claims and the green guides in particular, there is no private right of action for a private citizen to enforce the FTC Act. Let's start there. But there are several states that, for example, codify the green guides as law. California is an example, or have private rights of actions for state UDAP statutes that mirror the FTC Act or other, in the Federal Food Drug Act and others, that give plaintiffs a private right of action. And so that's where the risk is coming from. And that's where you're seeing a lot of the challenges come for companies regarding their green related claims or class actions under state law that are citing FTC guidance, for example, as per se evidence that whatever act or practice that they're doing is deceptive, among other things.
So we're coming up, unfortunately, at the top of the hour. So we just wanted to take a moment and say thank you everyone so much for joining us. As a reminder, we have 3 more panels in this series that will cover internal investigations, as well as ESG related due diligence in connection with corporate transactions, congressional investigations, and SEC investigations and disclosure obligations. So this now concludes our panel. As mentioned earlier, we'll send a follow-up email with a link to an evaluation and CLE credit material. And if any questions remain, I know we didn't get to all of them, please do contact us directly. And thank you everyone for attending.